kind of ignores the little ones. We also have a little baby. Well, we've already got a baby. Yeah.
Oh wow, you have a real array.
That was our attempt to get a dog from the water, and that dog runs away every other week. I mean, it's just she's so bad, but she just follows her mouth. We live, and we try to fence that stuff, and it's just impossible. And so I don't need enough. I don't want to hear it.
They're runners.
That's what I was telling them. We have one time. That's why I was like, it reminds me of the Empire State that the snow walkers walking around waiting to stomp on them.
When our little dog, we got toy Manchester Terrier, and so I don't know if you've ever seen them. They look like Dobermans, but they're not. They like the crates. Yes, very thin legs, tall, real tall. And when we first got our dog, I just thought, how could this be real? It was so small. It's the same portions and everything, but just so small. It's like having a little rat. Yeah, exactly.
Sarah broke a leg. They have for some reason. It looks very delicate.
We've already had the puppy already hurt his leg playing with one of our dogs.
See, we never, like Apollo we would literally strap on roller skates and tie a ski rope to his collar, and he would drag us up and down the street. We had a tire swing, and he had a tire that he dragged around the yard because he was 100 and almost 40 pounds. So he would drag a tire around the yard, so we decided to do a tire swing, and all we had to do was call him over, and he would grab the tire with us on board, pull it back as far as it would go with him still on the ground, and let go. He literally would swing us. I mean, he was just...
Maybe you missed out on the function of the
So that made him laugh.
One time someone sent my dog, it was like Poland,
Oh.
and so it turned out with that was when I found out. When I walked in, he slowly, and another gift from someone, and
See, that way there's never that. My dad used to take Apollo, Gator in general. Those were the three that we had. He would, you remember across from the YMCA there was that tiny little horse farm that had horse tracks. My dad would take his truck, put the tailgate down, and he would have to drive the truck in circles so that the dogs would chase the truck to get in there. Yeah.
You needed to go.
Yeah. Well, but I mean, none of us were fast enough to make it worth his while. He would be like, for real. Like, I would appreciate a challenge.
Well, we're gone next week. Pick a day and I'll come over.
the thing is, you might have to
Yeah, I was about to say, if you think you're going to see a puppy and then you're not going to hear about it, it's for infinity.
All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near. Give attention. You will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning. Our first case today is in re amendments to Florida Rules of Civil Procedure, case number 2023-0962. And before we start, I just want to acknowledge on behalf of the court just our gratitude to everybody who put so much time into this, going all the way back to the work group, and then everybody who commented on that, and the Civil Procedure Rules Committee, all the judges and practitioners who've weighed in. The comments were extremely thoughtful and thorough, and we know that this means a lot to the administration of justice in our state. We really want to get this right, and to the extent that we're able to, it will only be because of all the participation of everybody who put so much work into this. So we just want to say thank you before we get started.
May it please the court. My name is Lance Curry. I'm here on behalf of the Civil Procedure Rules Committee. Before I start, I just wanted to mention that Mr. Stratton is here, and he was also going to participate in the oral argument today on behalf of the eminent domain practitioners, and he agreed that he didn't need to participate because the committee has acknowledged that we just made a mistake when we did the initial report. We should have exempted all eminent domain actions, and our response to the comments provides a suggestion to the exemptions to include all eminent domain cases. I'm primarily here to answer any questions that the court has about our recommendations.
I can start out. So I think it was Judge Moe particularly that brought up there might be a sort of hybrid fourth track of cases types that are somewhere between kind of a normal civil case and maybe not meeting complex. Maybe you have a construction case with a lot of subcontractors or a medical malpractice case. Do you think these rules allow the possibility of an administrative order for that circuit to be able to sort of have an additional track that they can modify? Maybe they have a certain type of cases that are common there, or they want to put it on a track. Would that be a flexible option within the way the rules are done in your proposal?
I think it's doable, but it becomes a matter of semantics to a certain extent. I think the way the 13th Judicial Circuit refers to it as extended cases. Right. And in looking at it, several members of the committee thought it may be that those could fall simply under complex. Under this court's administrative order as it exists right now, the circuits are supposed to identify one of three tracks, and our proposals follow that. So it's general, streamlined, or complex. So it doesn't technically allow for some other category besides those three. But I think that, I think one thing that's important to remember is a circuit can have an administrative order that has a complex business division or some other special division and still designate a case as complex because it requires some extra attention. So you may have a medical malpractice case that isn't a business case. It's not going to go to the complex business division, yet it's complex enough that it needs some special attention and gets designated as complex. So I think that the existing administrative order and the proposals really try to limit things to those three specific designations, as opposed to allowing a bunch of additional identifiers, unless it's through a special division of the court that is identified by each circuit.
But do you see a problem with giving some flexibility for the sort of thing that's described, the extended cases? So basically, it's almost like a subcategory, or like it's like a 3A and B. It's like
No, Your Honor, I don't see a problem. I mean, the whole point, especially with the committee's recommendation of Track A, was to allow flexibility for the circuits. And we know that the court has recognized that it's important for the circuits to have that flexibility. And I think what's really important here is there is an exception to the general case management rules under these proposals for administrative orders that identify some special division, like the complex business court. I don't know why a court couldn't say we have an administrative order that identifies a special category of cases called extended cases.
Well, but it wouldn't necessarily be a special division. And I'm familiar with what you're talking about a special division, but I'm not sure that what we're focused on in this conversation exactly fits within that description. Am I missing something there?
No,
I mean, it's better for us. I mean, my view about this is that there's nothing to be said against clarity. I borrowed that from somebody else, but who said that before. And to the extent that we can spell it out so that people aren't having to worry about whether they're acting contrary to the framework we've established, it seems like that would be desirable.
I agree, Your Honor. The only concern that I have is that you don't want to allow circuits to have the super extended designation, and then you end up with a tremendous lack of uniformity because the circuits all have different names for things that really are the same.
I understand.
Let's go ahead. When you started. I spent, as you may know, I spent 13 years in the trial level, 6 or 7 of which was in the General Civil Division in Palm Beach County. And one of the most frustrating things for a judge is this whole business of continuances. And I remember especially setting a complex men-mal case or a products case or something like that for trial a year hence. Especially said, number one, you're going 4 weeks or served, all yours. And the morning of trial, when I take the bench thinking I'm going to select the jury, Judge, before you sit down for the jury, when you hear those words, to me, that was like, oh, God, here he goes. And counsel just amended his expert witness list with 5 new experts here the morning of trial. And, of course, I mean, that's enough to make a judge just blow his top off. Especially when you have them coming in a week before or 2 weeks before, and you're asking them or telling them, my calendar just washed, I got all this time, you got anything that I need to hear? Let's get it done so we can just pick a jury that day. And no, nothing. And then you get that morning. We have this case called Binger that basically tells you in those instances what the court has to do is a balancing test and consider the arguments and to see whether there's any prejudice. And that's the key, whether allowing those experts are going to prejudice the other side. Those who want the experts will tell you, well, those experts have all been mentioned in depositions, and they know they're there. They knew they were coming. And so you get those kind of things. I was looking forward to maybe something in the rules that would help us or help trial judges with that. And I see that you have sanctions for, I guess, what can be considered dilatory conduct by a lawyer. I wonder if that is considered such an act where you have the case for all these years and you set for trial, and the morning of trial, that's when you add 4 new experts, and then they tell you, you can't strike them, Judge, you got to do a Binger balance. Is there anything in these rules that helps judges with that?
I think there is, Your Honor. I think that first, just the fact that the rule is being revised at the direction of the court to make it clear to everyone in the bench and bar that continuances are disfavored, successive continuances extremely disfavored. That gives the trial judge, we're not doing this. Okay, the Florida Supreme Court has made it clear that we're not going to just willy-nilly give out continuances. And
the attorneys who are proposing the experts, they don't want the continuance. They don't want one. They say, no, you can't. You got to do a Binger balance.
And I think that's why, and this is something we adopted from the work group's proposal, there is a provision in their efforts to avoid continuances. And it basically tells the trial judge, if there's a way to avoid a continuance through some other means, by addressing the Binger issue after hours or whatever. Let's get it done. Let's figure out whether there's actual prejudice. We want to know right now before I grant any continuance. If not, why is there the delay in this new opinion? I might need to strike the new opinion.
But
So-
in looking at it, because I used to try a lot of cases before I went on the bench, and looking at it from the perspective of the lawyers involved, why should the person who now has to deal with his new expert, why can't that person just go home every night and prepare for the next day, like a normal person, instead of not having to go and cover depositions at night of the experts and doing all those things after hours? I mean, when you had the case specially set for a year, I mean, why should that have to be done?
It sounds like a great argument for there is prejudice here. You should strike this new opinion that was brought forth at the 11th hour after all this time to develop a case for a specially set trial. There is prejudice. We don't want a continuance. We're ready to go.
While we're talking about continuance, Chair, I want to focus on the specific language, and I think this is in both Track A and Track B of 1.460A. It says motions to continue trial are disfavored and should rarely be granted except for good cause shown.
Yeah.
That strikes me as I'm not sure I understand that, and that's different than the language we use. I mean, one way to understand that, I think, is that they could be granted without the showing of good cause, rarely. I know that's not what this meant, but if you look at it, I'm just not. Why is that language superior to the language that was in our referral order or our referral letter that should rarely be granted and then only upon good cause shown?
Yeah, I was just looking at the referral letter, rarely granted and then only upon good cause shown. Maybe I'm failing to see the distinction between the language and the proposal that I think we were intending to mirror the language in the referral letter. So if that language, if you're seeing this language in A as problematic, then
You don't see anything problematic about the language in the referral letter?
I do not.
Okay. And again, maybe I'm reading that I know what the intent is, but I know what it says, and looking at it literally.
We probably would have been safer to just pull the language directly from the referral letter there.
Could I also ask about, on that same topic of continuances, the efforts that you've listed that that I think the judge should consider all efforts, and then you list, I think, 4 things. What was the sort of idea behind listing those particular things? It seems like there could be other things that the trial court could consider. It seems like those things might not apply in every case. Do you see any disadvantage or advantage in maybe just saying the judge should consider every effort to avoid the continuance period without putting sort of a random grouping of items there?
So I'm almost sure that language came from the work group. Mm-hmm. It was not something that the committee, vetted. And there was always a question, anytime we put in there, including this, that, and the others, right. Should you say including but not limited to,
right.
To make it clear that you're not just identifying the 3 things that the court needs to consider. If the court had problems with those ideas as being suggestive of excluding others, then I think the committee would be fine taking that out.
Just with efforts.
It's just, I think those were specific suggestions that the work group thought would help trial judges in dealing with motions to continue.
Okay.
Can you give us your take on this projected versus actual trial date issue that the business law section raised, and just kind of, I mean, I know people have been responding to each other and stuff, but could you just kind of summarize that whole issue and
Sure.
give us your take on it?
Yeah. Under the court's existing administrative order, obviously it requires the courts the circuits to have an administrative order that issues a case management order designating a projected trial date. And of course that's important under our current structure because of the issue rule. The suggestion amongst the minority group on the committee and also the business law section is, well, you're doing away with the issue rule. Why do you need this vestige dealing with a proposed trial date? And the response to that is it's important to a lot of the circuits in the way that they are currently handling case management. And the Civil Procedure Committee's goal was to not disrupt the way the courts are doing things right now. This court's referral letter specifically said include a proposed trial date. And there's also this concern that if you have a requirement at the outset of the case that you set an actual trial date, once that actual trial date is set, you're in continuance land. You cannot change that actual trial date without filing a motion for continuance, and yet our rule is now saying disfavored, extremely disfavored, only good cause. So those were the primary reasons why we felt as a committee that it was important to, and allow the flexibility of the circuits to do it either way. If you look at the language, it says that you either need to do a proposed trial date, or if you want to do it this way, you can do an actual trial date. For example, the 12th Judicial Circuit, they do it a little differently. They have a case management order at the very beginning of the case. They bring the parties in, and they talk about all this stuff, and then all of these deadlines, and they ask the parties to help them set a actual trial date, so they don't use a projected trial date. And our committee was like, great, let the circuits have the flexibility to do it the way they want.
Let me ask you about the difference, if any, between a trial period and a trial date. Now, there's sometimes we refer in these proposals, it refers to a trial period. Other times, and mostly it refers to trial period, as I recall. But there are some times where it refers to trial date. Are those meant to designate different things, as in date as like a day, or a specific day where the trial will start, and then days of when it will go on, as opposed to a period of time where you need to be available for trial?
Yeah, I believe that the correct phrasing probably for most of the rules is trial period, because that's the way the circuits are doing it, as opposed to a court that specifically sets a trial to start on this trial date.
So if we were consistent in saying period as opposed to date, of course, that doesn't preclude you from having, saying it's a trial period. It can be a specific date.
Right.
It could be the period.
Because cases are set for a trial period, and then you got to see whether the first one it was set get settled and that sort of thing.
Well, some periods could be like, you could be writing, that's what we used to call it, you can be writing a 10-week docket, where the judge is setting aside 10 weeks to try cases, and you're number 5, number 6, number 7 for trial. So you're writing that docket, and as the case is before you fall, then you get called, and maybe you fall too, and the next one gets called. So it's just writing that depending on the length of the particular docket the judge has chosen to have.
Which is why you can't really use a trial date, because the first case might go 3 or 4 days and then settle, and then next up. So trial period, I think, is the appropriate phrase.
Do you think, I mean, if you didn't feel constrained either by what the circuits are doing right now or what we said in our letter, do you think that it makes sense to have the projected period option?
I do, Your Honor, and it's because I firmly believe that what this court has started with the administrative order from COVID is working in our system, and the last thing I think we want to do at this point is mess that up, is say we have to do it all differently now. Sorry, all the circuits need to go back and revisit all of their administrative orders that they worked so hard to implement in a short period of time so that we can have an actual trial date or an actual trial period set right away.
Could I ask about this service of initial disclosures for discovery? I think, that's a really important addition to the rules. Was there any discussion, though, with the committee that it does in some way, depending on the timing and what that number is after the service of the complaint, put a greater burden on the defense? I mean, unless there's a statute of limitations issue, the plaintiff has sort of unlimited time to prepare, pull things, understand experts, make sure they have documents before they ever serve the complaint. Yeah. But then you're fixing this very definite number for a defendant to pull that same information within an arguably much shorter amount of time. Was there any concern on the committee about that? Is that not an issue at all? on that?
I think the committee was not overly concerned because this is exactly how they do it in federal court, and defendants seem to be able to manage okay in federal court doing this kind of stuff. I know the problem when you transition from the federal court world to the state court world is you're talking about a lot more cases, and a lot of cases that maybe aren't as significant value as the cases in federal court. I think the goal and the impetus of the rule and the request from the court is to get parties talking about discovery and those sorts of issues, and hopefully what it results in is parties talking, and if defense counsel says, hey, I just got into the case, I need more time to actually pull the documents together, then that's something that the parties will be able to work out.
Could I ask you a question about failure to appear? I understand that was generated some controversy, and I guess it was in Track A, but then it was taken out, or I can't.
So it was in.
I can't keep you keeping track of what's in what track and when it got changed. I don't know, but
well, these I think are the same in Track B. But essentially, what it is the current rule right now says that if anyone fails to appear at a conference, the court can strike the pleadings, dismiss the action, or take any other appropriate action, words to that effect. And the committee, and this is also following the work group, felt like it was unnecessary. That's something that's within the inherent authority of the court to do that. So what we did is, following the work group, we added a provision that if nobody shows up at a case management conference, what do you do? Well, the court then can decide that, well, this case must be settled, so I'm going to dismiss the case. And then we got the comment, I think were good comments, saying, well, all you've done now is you've taken out the provision that says you can sanction a party, any party that doesn't show up, and now you've added something if nobody appears. And at the end of the day, we felt like, you know what, this is something that less is more, that you don't need these directives in the rules about sanctions. If somebody doesn't, and some of the judges had pointed out that, you know, we put this in our orders that go out, either administrative order or an order requiring a case management conference or a pretrial conference, that if you don't show up, you could be subject to sanctions.
Well, I guess part of what confused me about this was I understand that part of the concern was that the way it was framed, a party who showed up could end up being on the receiving end of some adverse action by the court, which made no sense. If you read it literally. But my question is this: couldn't you just leave it the way you had it, and just at the end where it said, on failure of a party to attend a conference, the court may dismiss the action, strike the pleadings, limit proof or witnesses, or take any other appropriate action, and just add the words against a party failing to attend? It seems like that's a pretty simple way to address the concerns that were there, but have this explicitly in the rule that, you know, if you don't show up, the hammer may come down on you. Is there a problem with that?
Were you just reading from the existing rule or from our proposal?
That's actually a different language, because I guess
I think that's from the existing rule. I'm sorry, because what happened was we took that language out, and I agree. I think if you're going to include any language, the old language, the way you rephrased it, is better than what we were proposing, because our proposal was specific to nobody showing up. Not one party not showing up, nobody shows up. And in fact, the work groups had said, their proposal had said, if neither party shows up, and we were like, well, there's a lot of cases with more than two parties, so if we went to if none, and I think that created the problem.
But you don't see a problem with
retaining that old
retaining language that just focuses on
right.
Bad things happening to whoever doesn't show up.
I don't think anyone on the committee would be upset if that old language was retained. It's the inherent authority of the court to sanction someone for not showing up, whether it's stated in the rule or not.
Yeah, can I just ask you a terminology question? I think it was Ms. Lucas' comment that raised the issue of noticing a case management conference setting versus filing a motion. What's the committee's take on what the most uniform language is in that regard?
Yeah, so that was Megan's comment, and I think she's right. Yeah, that it doesn't make sense efficiently to have a motion to set a case management conference as opposed to simply setting one with the court. So I think that she's correct on that. It's not something, it's maybe something that the committee kind of glossed over while doing the work, but I think the appropriate way to address that is that a party can set a case management conference.
Mm-hmm.
Okay, thank you very much.
Thank you.
May it please the court, my name is Megan Peek-Luca, and I am here on what are largely granular issues, but they were important enough to me to drive 4 hours to say, please pay attention to these. I have 10 grains of sand in Rule 1.200. And the first one, I'm in my appendix. I don't know if you all have it. It's A7 for me. It's the case track assignments. And for streamlined cases, the committee voted to say that a trial length of less than 2 days is considered streamlined. Less than 2 days is technically one. So what we're saying is only 1 day trials are streamlined. The number is unnecessary. Just say short anticipated trial length. Then you've got flexibility for 1, 2, or 3. And I think that you should also include that uncontested cases should be considered streamlined. It's my appendix A13. It's on deadline enforcement and changes. I do appellate law, words matter, the order of the words matter. The committee said that the case management order must indicate that deadlines will be strictly enforced. The requirement for you to write it in the case management order is, it doesn't mean a whole lot. I think the language should be that deadlines must be strictly enforced. And I think that it should say, unless changed by court order. Justice Kennedy, you spoke my love language. There's nothing to be said against clarity. They're in the trenches. We are living in a hypertextualism era where some lawyers will look for words or look for words that aren't there, and they will make arguments that would be absurd in light of the fact that you can make a motion to extend deadlines. But I would argue that this is a situation where having these 5 extra words brings clarity, so include them. And
where is that in do you know in Track A where that is? So
yes, Your Honor, it's under 1.200, I believe it's B3. It's called strict enforcement of deadlines is the name of the, or here, hold on one second. C3, Your Honor, sorry.
And what is it that you want this to say?
Instead of having a number 3, I would merge 3 and 5, and I would say deadlines in a case management order must be strictly enforced unless changed by court order, in lieu of the number 3 that is in Track A.
What is the specific section you're talking about there? I'm
Do
sorry.
you guys have the color coded one?
1.200C3.
I'm sorry. 1.200.
200C, lowercase c, numeral 3.
Okay. Since you drove 4 hours.
I think we had already looked at that recommendation pretty closely. It's a good one.
The other thing that I would urge is that Track B proposed that once an actual trial period is set, you have to satisfy the requirements of Rule 1.460, which is the continuance rule, where it's much harder to move the date. While you're still projected, you can simply file a motion. However, whether you're going to file a motion to move your projected trial date or whether you're going to file a motion to move just a deadline in your case, your discovery cutoff, your Daubert deadline, whatever it is, I chaired the committee that wrote Rule 1.460. We had a lot of judicial participation, and the judges gave a lot of input about what is helpful to them when they're trying to decide a motion to continue, what they'd like to know in advance. Like, Justice Laberga, how long long have you known that you needed this extension? How long did you sit on this? Have you talked to your opposing party? Are they in agreement about the concept of an extension? Are they in agreement about the specific date that you're requesting? Have you actually talked to your experts or your witnesses or whoever to confirm that the date that you're asking me for is actually doable? These are things that the judges said, if you can tell us this in advance, it helps us evaluate. It's a good exercise to require the parties to do it, because a lot of times judges say, they'll come to us and they'll say, we want an extension, and the judge will say, well, what do you want? And they will have to look at their opposing counsel and get back to the judge, and it just drags the process out. Make them do their homework first. So we require that as part of Rule 1.460 if you want a continuance. And Track B's, the committee's position was, why shouldn't you have to do that if you want to continue any other date? It's helpful to the judge. And it is my personal opinion, based on absolutely no scientific evidence, that part of the decline in our attorneys' abilities to be cordial with each other, and sometimes just even professional, is that we don't talk to each other as much. We're not required to talk to each other as much. And when you have to pick up the phone and tell your opponent, I'm not jerking you around, my kid got really sick, and I wasn't able to complete this, and I just need some extra time, then that allows you to be human beings and to be kinder to each other. And I actually think that that's really important. So I feel very strongly about including those requirements if you want to extend a deadline. Give the court this information, require you to speak to your opponent. Under changes in track assignments, which is C5 in Track A. Again, this is just a matter of clarity. I think that we should say at the outset, the very first sentence should be that parties may by motion seek to change track assignment. And I say that because if you are a pro se litigant and you are 4 pages deep into a very long rule, just put it up front so that they know that this track assignment thing that they've just been told about, they aren't stuck with it. If they can file a motion and explain why it needs to be changed, then it can be changed. And I think it's also important to make it clear to the judges that they have the ability to change the track, because there are some of them who feel very constrained. They don't want to get in trouble. They don't want to deviate. And in a construction case, for example, you start out with 1 defendant, and then fingers start pointing, and you're 10 defendants deep 6 months into the case. What started out as a general case is now complex, and the parties might not be the ones moving for it, and the judge might be the one who says, wait a minute, I don't want to have to ask you to file a motion. I'm just going to tell you this is now complex. So I think that you need to make it clear to courts, to judges, that they have that ability.
Do you have any suggestions on there was varying suggestions in the tracks on what needs to be included in a request to change a track? Do you see any issue with just kind of leaving that language broad to allow the trial court discretion?
Your Honor, as someone who loves the minutia, even I feel like that is one where you might be better off. Like in the complex rule, if you want to be complex, there are some requirements about what you need to tell the court. And I feel like that rule is enough to help create the kind of guidance that you need in order to, what I envision honestly happening most often is going from general to complex. And the complex rule does designate what criteria are necessary, so I'm not sure that it's helpful to try to envision what factors might be necessary. But if the court thinks there is, then I think it would be a good exercise for the committee to talk about it. I have another one that it's actually 3 provisions in a row that were included in Track B. And again, feel super strongly, I would have driven just to tell you about this one. So it is case management conferences. It is subdivision E in Track A. And in Track B, for scheduling, the Track B has everything that Track A has, but we expanded on the notion. because we said, if you're a party and you want a case management conference, okay, first of all, a judge.
This is whatever J in
This is J in mine, Your Honor. It's E in A proposal. It is subdivision E.
But it's J in track B.
It's J in track B, yes. And I'm so excited that you knew that. It wasn't for nothing. Okay. A judge can always notice a case management conference. This is a clown car. Y'all are going to need to come in and tell me what's going on. What track B did is we said, look, if the parties are noticing it, then the cost of admission, if you want a piece of the court's time, you're going to need to do an inventory of your case. And this is something that we looked at. It was something the work group recommended, and we felt like it was a good idea. It's a case management tool. Basically, if we can't agree on how we're going to schedule depositions, and we want to go talk to the court about that, we are going to have to go through and list every motion that's pending in our case. That has nothing to do with why the parties want to talk to the court, but it is a tool for the court, because then the court can look at it, and it's just a way for the court to touch the case and say, all right, no motions pending. Great, this is going swell. Or, oh my gosh, there's 10 motions pending. So that when the parties get in there to bicker about the order of depositions, the judge can say, I'd also like to talk about these 10. Have you set them for hearing? Is it important? Can you get them off the docket? Have you talked about resolving it? Where are we on this? Because that allows the court to keep an eye on what's going on in the case. So track B says that if noticed by the party, the notice itself must identify the specific issues to be addressed during the case management conference, because judges said, a lot of times we get a notice and we have no idea what they want to talk about. We show up and that's the first time we hear it. So tell us what you want to talk about, and then tell us what your pending motions are.
Can I actually have a note to ask you a question about JC2? It says, I think that the court may elect to hear a pending motion other than motions for summary judgment and motions requiring evidentiary hearings, even if the parties have not identified the motion as an issue to be resolved. What does that, what would that be?
Your Honor, when that was drafted, the specific thought was, because it was an example that came up amongst a lot of the judges, motions to dismiss. They can get a year into the case and there's still a motion to dismiss pending. And so right now it's a problem because that makes the case not at issue. But further down the line, the defense lawyers in the committee said, well, wait a minute, you know, the at issue rule is gone, which means that you could theoretically go to trial even though a motion to dismiss is pending. And the judges on the committee said, yeah, if you've allowed a motion to dismiss to sit there for 18 months, we do not feel sorry for you. That was your job to get that called up. And so what this rule is envisioning is you give the judge the inventory, the judge can look at it and say, you know, okay, we're 8 months in, I'm going to make sure that they know that they need to get this noticed. Or they can say, you know what, I'm going to give the parties reasonable notice, and I'm going to move some things around, so this 15-minute hearing is now a 30-minute hearing, and you're going to be arguing the motion to dismiss during the case management conference. But the reason that we included that it can't be summary judgment is obviously because our summary judgment rule requires very specific timing points, and if it's an evidentiary hearing, obviously you don't want to be conducting an evidentiary hearing during a case management conference. So we wanted to protect due process.
Thank you.
And thank you for asking. The provision immediately before that is to provide clarity, which is that preparation required is the name of the paragraph. It's E2 in Track A's provision. Track B's provision contains all of the information that Track A did, but we break it down into an ABC lettered paragraph. Stylistically, I like the clarity. But it's not just style, it's also that Track A says that the parties must be prepared on the pending matters. And Track B felt like, what does that mean? Does that mean prepared to talk about them? Prepared to argue them? Let's create some clarity here and say that the parties must be prepared to argue pending motions that are noticed by the court. Because we wanted a situation where the court would have to give notice, this is what I want to hear, and the parties need to be prepared to argue those. A party is never going to be arguing their own motion because they're going to notice that for a separate hearing. Parties don't notice motions to be heard during case management conferences. Case management conferences and notices of hearing are different. So I really like these three provisions together as a case management tool, and I think that they're valuable. Miscellaneous provisions, their G4 is something that appears in Track A. It's called revisiting deadlines. Track B voted to delete this because it says at any conference under this rule, the court may revisit any of the deadlines previously set where the parties have demonstrated a good faith attempt to comply with the deadlines or have demonstrated a significant change of circumstances, such as the addition of new parties. The reason Track B voted to delete this is because, first of all, a judge can always revisit a deadline. You don't need a rule that says that. Second of all, more importantly, the appellate attorneys leading the charge felt like it was creating a different standard because right now the standard for changing a deadline is good cause. This says that the court can revisit a deadline where the parties have demonstrated a good faith attempt to comply with the deadlines or a significant change of circumstances. What if your good cause doesn't fit into one of those two categories? My concern is that this rule in Track A creates a different criteria for how you change a deadline. It needs to just be good cause, which is why that provision is just unnecessary.
Sorry, what part are you talking about?
G4 in Track A.
What was that?
It looks like it just says G. There's no number.
I'm sorry. Which appendix are you looking at?
I'm looking at the revised Track A after the response to the comment,
Okay.
so amended Appendix B.
Give me 1 second.
Is this inability to meet case management deadlines?
No, Your Honor, it's called revisiting deadlines. Give me 1 second. It is amended Appendix B9 is the page number, and it's paragraph 4, which is the first paragraph at the top of the page. And it is my suggestion that you need to delete the paragraph altogether because you don't need a rule that says a judge can change a deadline. They can always do that. And more importantly, this says that a judge can change it where there's been a good faith attempt to comply with the deadlines or where the parties both have demonstrated a good faith attempt to comply with deadlines or there's a significant change of circumstances. So what happens if your opposing counsel has not demonstrated a good faith attempt to comply with the deadlines and you are moving to extend the discovery cutoff because they won't cooperate with you and they haven't produced documents and you've had to file 6 motions to compel? That's not a significant change of circumstances like the addition of new parties, and that's not the parties working together in good faith. But it is good cause. So delete that paragraph. There is another paragraph which is, that one got deleted, never mind. Track B recommended a paragraph, it's J4 in the Track B proposal. It's appendix, it's A45 in my comments. It's a housekeeping measure. So the at issue rule has now been deleted and you have to file if you are on a case management plan, you get a projected trial date, you have to at some point turn your projected trial date into an actual trial date. And Rule 1.440 now says that you need to move to create your actual trial date if you don't have one or if you want one earlier than your actual projected trial date. J4 in Track B is a housekeeping measure because it just says if you get to 60 days before your projected trial date and you haven't gotten an order that turns it into an actual trial date, then it is the party's obligation to file the motion and notify the court. Basically, if something slips through the cracks, it's on the parties to make sure that 60 days out you have converted your projected trial date into an actual trial date. We've already talked about failure to appear, and my concern would be that deleting it, people and potentially judges would read something into the fact that it was deleted, that it meant it was a deletion of the power. I think keeping it the way that it is a good idea.
Did you see a problem with what I suggested?
No, Your Honor, I think that you're correct.
How many days before did you think the projected trial date?
Track B had recommended 60. We're not wed to that number. We just felt like if nobody has complained and you're 60 days out, you're probably going to hit that trial date. You just need to notify the court that they haven't entered the order yet. If the trial is not reached during the trial period, this was a comment from the judges, and I think that it's well taken. Track A says that they should enter an order setting a new trial period as soon as practicable, and I felt like saying, given the needs of the case and the resources of the court, is a good clause to add so that judges know or have a little bit of a better idea of what as soon as practicable means. Again, just clarity. Under Rule 1.201, the paragraph B3, it's talking about trial dates, and I think it's important to say at the very last sentence of B3, it currently says continuance of the trial of a complex action should be rarely granted and then only upon good cause shown. I think that it would be better to say continuance of the trial of a complex action will be governed by Rule 1.460, because then it is crystal clear that whether you are general, streamlined, or complex, everybody has to meet the criteria of Rule 1.460, because there's no reason that a trial that is considered complex shouldn't have to explain to the judge when they realize they needed the continuance, whether they can meet the date, whether it's objected to, whether the other party agrees to the date, all of those things. So it's a little bit of a housekeeping measure, but I think it's important to make sure that it's clear that everybody is governed by the same standard. Under the case management order, so I put together a presentation and I gave it to a lot of judges, and that's how I got a lot of judicial input about the suggestions that we had made. And one suggestion is that Track A doesn't require issuance of a case management order in any certain time period after the case management conference in a complex matter. So Track B suggested that you need to have a deadline for that. So within 10 days of completion of the case management conference, the judge should issue the case management order. This is only in complex cases.
Only in complex cases?
Only in complex cases, Your Honor.
Do you think there should be a deadline in the regular case management cases?
I think that would probably be impossible, Your Honor. For jurisdictions that do not have, for example, I'm thinking of a Pasco County judge who told me after the presentation that they had special funding to have case managers who are drafting orders and entering them for them, and that funding expires, I think, at the end of this year. And they're concerned about going forward how they're going to get those orders issued.
So to just generally have a rule that said within 10 days after completion of a case management conference, the judge must enter an order for all cases, you think that would be an impossible task for many circuits?
Well, Your Honor, if you're in a general case, you're not necessarily having a case management conference in order to get a case management order issued.
Okay.
So, for example, in Hillsborough County, your case management order issues within 30 minutes of filing the complaint because it's automated. In Pasco County, you're going to wait significantly longer because a judge is going to have to manually sit down and enter that. So, which was the purpose of this rule, is to make the process of getting case management orders issued more efficient. One thing that this was actually input from Judge Bailey, who has a master's degree, I believe, and had done a ton of research, and it was about cancellation of hearing time. Track A in paragraph C4 says that the parties have to confer no later than 15 days prior to the case management hearing, and they have to notify the court 10 days in advance of the hearing if they don't need the time. And track B said you should make it so that the language says whenever possible, the parties should notify the court 7 days in advance. 7 days because A, it will make sure it's a business day, barring a holiday, as opposed to 10. Lawyers get very weird when something falls on a weekend. And the other reason that you need to say whenever possible, and then say even if 7 days notice is not possible, still notify the court, it's because lawyers get so scared that they feel like, okay, we resolved this 4 days beforehand, but the rule says that we have to notify the court at least 7 days beforehand. So now they're going to show up and waste the court's time to say, we couldn't give you 7 days notice, so we're here to tell you we resolved it. And the judges said that drives me absolutely bonkers. Please create the flexibility for the parties to be able to notify us, even if it's only 2 days in advance, and we can use our time more wisely. Or give it to someone else. In Rule 1.280, where you're talking about having a conference of the parties to talk about discovery issues, in the full committee meeting that we had in June at the Florida Bar Conference, the defense lawyers raised the point that the meeting is supposed to happen as soon as practicable, but in any event, no more than 60 days after the first defendant is served. And the defense lawyers said, the defendants don't know who the co-defendants are. The plaintiffs are the ones who have the knowledge of who got served when. So it should be on the plaintiffs to arrange the conference. And I primarily do plaintiffs' laws, and I agree. That's a very practical point. But I think the counterbalance is plaintiffs are in charge of getting the ball rolling. All parties are tasked with cooperating with each other to make sure that the conference happens. And because we are in an era where perhaps making it very explicit to attorneys that they have to cooperate with each other, I think has become prudent. My suggestion is that we include a sentence that says the plaintiff is responsible for initiating the scheduling of the conference, but all parties are required to cooperate in scheduling the conference, and the parties are jointly responsible for conferring in good faith. So, last one, promise. Rule 1.440. A lot of judges approached me after giving the presentation and said, here's the thing about the at-issue rule as it is and 1.440 as proposed. We don't know when motions get filed. We have thousands of cases. Nobody is giving us a list every day of every motion that got filed in every case. That's not how it works. If you're going to have this new system where you have to file a motion in order to get your trial date, we think that's great, but somehow the parties have to notify us that it's there. And every circuit is going to do it differently. And so that's why I proposed that the last sentence of 1.440B state that the parties must notify the court in the method specified by the judge that such a motion has been filed. So that if one judge has a spectacular JA and she's so on top of it and she really does look to see every motion filed that day, send it to my JA. If you've got another system, do it that way.
So just notice to the judge.
Correct. And then I don't think I need to say it because the committee voted to adopt it, but my amended comments said that I think that for the purposes of consistency, that, Your Honor, Justice Kennedy, you had said you had proposed language for Rule 1.460A, and I think that it needs to say motions to continue trial are disfavored and should rarely be granted unless good cause is shown, including meeting the criteria set forth in Rule of Judicial Administration 2.570. That provision was created because there were some justices or judges who were denying motions to continue where attorneys were pregnant or where their partner was pregnant or where they were adopting a baby. And so Rule 2.570 was created to state that if those are the circumstances, then you need to, that is good cause, and to create consistency and ensure that that right is protected, I believe that you should, and the committee adopted, include that synchronization.
Okay, just a quick question while we have you. It's outside the scope of this, but I'm curious what your thoughts are on Judge Mo's point in her comments about tying responses to summary judgment motions to the date of filing rather than the hearing date?
I actually think that it's a good idea. I think that you could avoid a lot of delays by doing that. I think that it would probably help manage cases because, as she noted in her comment, you do have a lot of circumstances where you get close to trial and the judge has a Hobson's choice. You know, do I rule on the motion for summary judgment, which could obviate the need for the trial, but the moving party waited until too late to file that motion? And particularly in Hillsborough County, I would love to see the deadline for the motion for summary judgment and the Daubert motions included in the initial case management order. So track A proposed 7 dates. I'd love to see those 2 particular dates go into the deadlines. And Judge Moe and I had a conversation about it. And as the summary judgment rule works right now, that wouldn't be functional for the automated system. But if the summary judgment rule were to change, then that would become an option. And like Mr. Curry said, no one on the committee wants to fix things that aren't broken. Hillsborough County, Miami-Dade, and I think there's one other, and I'm not sure what it is, they are spinning like a top. They've got a system and it works. We don't want to break that system. We don't want to do anything in these rules that would break that system. But that is one particular thing that I think might help move the system along in a smoother fashion.
Okay.
And one last thing, I think Lance and I had discussed this, and he didn't mention it, and he can tell me if he disagrees now, but as someone who chaired a lot of these committees or subcommittees, we would ask that the court give us one more opportunity. We worked very hard and we worked very quickly to try to get you everything by the deadlines that you provided, but in the end, after the comments, we ran into a time crunch. And I think some of us who are a little more tightly wound are nervous that we haven't dotted all the I's and crossed all the T's and smoothed it all out so that the language is always consistent. And we, if the court would indulge us, would like an opportunity to have just one more brief period of time to go through it and make sure that we have smoothed out all the lumps in the mashed potatoes.
Okay, thanks. And you've personally gone above and beyond the call of duty with all this stuff, so
Chief,
we really appreciate it.
Could I ask her one quick question?
Yeah.
Do you think any deadline should be included in the case management order about alternative dispute resolution or mediation dates?
Yes, Your Honor. Actually, that's a really good point. Thank you. It was in my comment. I just didn't. Okay. I've already gone over my time. I didn't make it.
That's okay. I just wanted, that was something that you felt was important.
Track A lists the last deadline. The 7th deadline is a deadline for mediation, and I put in my comment it needs to be mediation, alternative dispute resolution, or arbitration. It needs to include all 3 because you never know. Some judges might want you to do all 3. Some cases you might need, you can only do 1. It needs to include all 3. Thank you.
May it please the court. It's a pleasure to be here. Thank you for giving us this time. And I want to thank the Rules Committee and especially Ms. Luca, who I think has just done an amazing job of trying to pull together what's otherwise a bit of a confusing series of rules. So my purpose here today is really to primarily answer your questions and just to identify if there's anything that you need to know that I could help you with. But I will tell you that as I was looking at the rules and going through all the materials last night, I looked at it and had maybe a different feeling about the 4-hour drive. I wanted to go right back because this is, if I were in your shoes, I would find this very difficult to make a way through. And I think that is despite phenomenal efforts by everyone who has put themselves into this. I don't mean that as any criticism, but this has gotten into a very technical, the proposals you're being asked to consider are significant changes, some of which have a lot of little nits and pieces that will really change the way things are working and potentially will have significant unintended consequences. And so I would not want to be in your shoes. I appreciate the time and attention you're going to give it.
Can I ask you a question?
Yes.
Sorry, I'm glad you're here. Thank you for being here. There's, to me, somewhat of a tension. there's a tension between other hearings convertible, which I think is from track B, and the issues that may be addressed, this kind of like when you can convert any hearing to a case management conference. Because we have, there's the suggestion that the court needs enough notice before a case management conference is set. And then I think this is from track A, a provision that says that any scheduled hearing may be converted sua sponte by agreement of the parties to a case management conference. So I'm just envisioning people walking into short matters. You have 5 minutes set, and they're like, well, we are allowed to, and we want a case management conference right now. Do you see any issue with this conversion provision and the way that would work in practice?
I think as a practical matter, it would be helpful for the judge to be able to convert any hearing into a case management conference. As a practical matter, that will probably happen if there's time, and if the matter notice prompts a case management need, it makes more sense to, while you have them there, to do it. On a short matters docket, the chances that our short matters is 5 to 7 minutes. The chances that anything can be done other than just the most basic things in 5 to 7 minutes, they're very low that you could add anything onto that. But I would be in favor of a rule that allowed us, as I think the rule currently does, to take up case management when it seems appropriate and you have time at any point in the case. Now, that would be different if the case management rule allowed, for example, for us to spontaneously rule on dispositive motions that weren't noticed. I mean, I think motions to dismiss are clearly different. I don't even know that there's any entitlement to a hearing on a motion to dismiss, so I don't know that there's any unfair surprise if the judge happens to be able to rule on a motion to dismiss at a case management conference, although typically you would want to do that after you'd also ordered a response.
And that seems to be court-led the way it's drafted right now. I mean, do you have an issue with the way it's drafted right now with the kind of any other motions language, as long as it's court-led?
I don't have an issue with the way the current rule is about case management conferences, and so I think that the problem with some of these different tracks is that they've wound themselves into a level of complexity that it will be difficult to extricate and identify what's going to be helpful and what won't be helpful on that particular point.
So is there you said that getting into the weeds was stressing you out about unintended consequences. Is there any specific one or two things that, I mean, there is going to be obviously a certain amount of just transition that's going to have to happen, but I mean, is there anything that you think is kind of obvious right now that we would want to take a close look at? Or?
Well, a few things. So, Justice Labarga, you asked the question about that 4-week docket. You got a med mal case. You have been on them. You believe that you, as the judge, need to be the captain of the ship. You've done everything you can to get that ship steered to a final conclusion, and then they walk in the morning of trial and say, we've just disclosed a new expert. There's part of the concern that I have is that some of these rules are, in essence, acting as if the case management order itself, the order that set the scheduling order that sets the deadlines, can't help with those issues. That's a particular issue that in Tampa, in Hillsborough County, when we got the administrative order, the COVID administrative order, we sat down and said, all right, if we're really going to do this and we're really going to try cases in 18 months, regardless of what kind they are, what would it take in addition to what the rules already provide for that to actually be possible and fair? And one of the things we considered was the exact scenario that you posed. And so the way we dealt with that is when we had to come up with a scheduling order, we didn't just come up with a scheduling order that has deadlines. We have text above the chart. And that everything in that text above the chart, if you would like to know what I think we need to do to make sure we can try cases on time in 18 months and have it be fair, it's the text above the chart. And we require that you have not only an expert disclosure deadline, but you have that expert disclosure is defined as not just tell me who your expert is, but tell me everything you need to know about that expert to be able to be prepared to identify, do I need to depose that expert? We also have to give 5 deposition dates for that expert at the time that you disclose them. And all 5 of those deposition dates need to be before the close of expert discovery. I had a pretrial conference yesterday. I hold my pretrial conferences 30 days in advance, and I had almost precisely the scenario that you had just posed. It wasn't a 4-week trial, but the first thing I did is I said, let's go look back at our deadlines, and then look, did you do this by this deadline? Did you do this by this deadline? And it was so much simpler to identify what the fair outcome should be and where the consequences of things should fall because of the text above the chart. So I think that's one of the things that I would say is expert disclosure, having more specifics about what expert disclosure means. There's always been substantial disagreement among some people, and we put that to bed in Tampa. That's really helped. Requiring the expert disclosure include the deposition dates that all are before the close of expert discovery has put to bed a significant amount of controversy, again, because it's very easy to see where the problem lies if they come in on that scenario. If you haven't deposed yet, well, did you get the 5 dates that they gave you, and what did you do with those 5 dates? But the summary judgment rule change would be, whatever you do with 1.200, I mean, you could spend lots and lots of time making 1.200 absolutely beautiful. And if you do, but we leave the summary judgment rule alone, we will still have continuance after continuance after continuance.
Meaning you're talking about the response issue?
Yes.
Okay.
So because that is, the reason for this is that there can be that problem in the absence of anyone doing anything improper. So the judge may be trying to do everything that he or she can. The lawyers may be they may have timely filed that motion for summary judgment. They may have all been working together diligently to try to secure hearing time, but yet hearing time just simply may not be available, or hearing time may have only been available when they legitimately could not have that hearing. And so suddenly you get to the pretrial conference, the judge has time in the next 30 days set aside to resolve whatever issues may be still pending in the cases that are set for the upcoming trial period. But the judge can't currently set that summary judgment motion absent a stipulation of the parties that they would agree to waive the time periods under the rule if they're willing to do that, which no one really is. But right now, you have to continue that trial, which is why when you look at the 2-order system in Tampa, we have the scheduling order that's entered when the case is filed. That has all of your pretrial deadlines and your projected trial month. You get your trial order, and that's when you get your trial order, you're being set for the week that the judge is trying cases in that projected trial month. And then backed out from there is your Daubert summary judgment, expert list, exhibit list, witness list, etc. If you put, and I was explaining this to Ms. Luca, if we were to take Daubert and summary judgment out of the trial order and put it into the case management order, then in those situations where we have the continuance because of the summary judgment, we would essentially have to amend both orders to reopen the deadline for the summary judgment to be heard and the summary judgment issues at the same time that we're continuing the trial. Currently, if I'm in that scenario, I only have to amend the trial order because everything that's expired is in the scheduling order. That sounds like nothing, but if you look at the appendix to my comment, I put the 2 orders so you can see them side by side. That's not an insignificant issue, but it would be solved. Like, we could much more easily do what she's asking for if that summary judgment rule was fixed.
Could you address your comment about having sort of a 4th option that's circuit specific or by administrative order for just a kind of, I think you called it extended in Hillsborough, and why you think that's important?
Well, first of all, as I mentioned in my comment, context is everything so often, and the context of the 13th Circuit's process is the same as everybody else's process, except that we had an existing complex business division. And so that there's an initial screening for complex business division on our civil cover sheet. And so people can indicate on the civil cover sheet whether their case is complex. We decided to tie our 3 other tracks, simplified, general, and extended, to the case types designated on the civil cover sheet. In essence, we would have, there's two different kinds of cases then, two different categories of cases that would both be complex. There'd be the complex business cases. And maybe one way to think of the difference between a complex business case and a med mal case or a construction defect case is the number of lawyers who represent the same party. You know, you have in a complex business case, you may have 3 firms representing one party. You've got, you know, and then you have local counsel. So in a med mal case, you probably only have 1 lawyer representing each medical care provider. And probably, maybe you might have 2 lawyers representing the plaintiff, but you just don't have, the level of complexity is simply not the same between what we call extended and what we call a complex business division case. It was never our intent, and I think that we are concerned. You know, have we done something that is an offense against what was intended with the COVID administrative order? I think we haven't, because I think that the intention of it is clear, and I think it's a semantic issue, but I think we would really appreciate knowing that we hadn't, in an effort that on our part was clearly trying to be compliant and to do exactly what you asked us to do, Justice Kennedy, we would be horrified if what we were doing was something that was not consistent with your intent.
Can I just ask you a big picture? Do you think that, whether it's track A or track B or a combination, do you think that these deadlines are achievable given how hard it is to find hearing time in some jurisdictions, or is this kind of like a pie in the sky goal, and in reality you're just going to see more motions to continue than you ever have? Well,
I think, again, there's difference between Tampa and everybody else even in that answer, because we instituted what we call Division HT after the surge of cases that were filed in March of 2023. As a result, for a period of time, I had literally half of Tampa's docket as my cases. Now, so we took them all, we stayed them, and we've time released them back into the system, which means that no judge is slammed in a way that they simply can't handle. I don't know how it's worked elsewhere. I can't say one way or the other, but that is why we probably will be in a position to, as long as we have some lead time, if we need to make changes, we'll be in a position, I think, we're in good shape. But I think the reality of that surge of cases filed in March of 2023 is one that I hope the court will consider when it chooses an effective date, if there's going to be a radical change, because there will really need to be some significant time, even a small change. If we have to, in the 13th Circuit, make a small change to our system, it requires touches from so many different people and so many different, I hate to call them stakeholders because I never quite know what other people mean by that word, but so many different parts of the court and all the different functions would have to be involved. Even something small will be a big deal for us to have to change. But if it's something big, particularly when everyone is working on overdrive on the plaintiff's bar, the defense bar, the court, hearing time is very difficult to come by right now, and that's true despite how hard everyone is working. So I do think that my answer to some of the questions and some of my thought about what should be done with this rule has changed in the last year because of what else has changed in the last year. And I appreciate that question.
I have one small question for you. First, I want to thank you for an extremely readable and helpful comment. It's wonderful. My question is about the meet and confer requirement for non-dispositive motions. And I'm wondering what teeth you think the rule needs, if any, to achieve the goals that Ms. Luca was talking about. In federal court, a failure to file a sufficient meet and confer statement in a non-dispositive motion will get it stricken before anyone responds. That, of course, requires someone tracking filings in the case with sort of an eagle eye, which I understand is not going to be possible, across 67 counties in the state. Do you have a suggestion for what might actually put some force behind the meet and confer requirement so that there is a meaningful consequence if someone fails to sufficiently meet and confer and certify that it's happened?
Your Honor, what I would tell you is that the certificate of good faith conferral that we require in our, again, the text above the chart in our DCM order has been very fruitful. When I started in Circuit Civil in January of 2021, when I started in January of 2021, it was almost never true that there had been a meaningful conferral in advance of a hearing. And what that meant as a practical matter is that repeatedly we would come in and sit down, and really nice lawyers, one of them would launch in, they would reserve 30 minutes, we would 15 minutes in, the movement would stop, and then the non-movement would say, you know, Your Honor, we work really well together, and I hear what they're saying, and I don't have any problem with what they're asking you to do. And
It's a giant waste of everyone's time.
I mean, most importantly, it's a huge waste of our resources, because while I enjoy the time that I spent with them, I like my job very much, I'm very happy to be there, I don't resent them, but I feel very bad for all the people who really couldn't have worked out their issue.
Or you know, just the point we were discussing earlier about hearing time being a real driver, like the most critical scarcity. Mm-hmm. So I'm just wondering, like, functionally, do you make it part of a form that the matter cannot proceed without, like it's some sort of checkbox that needs to be done, or else the filing gets bounced? Just like mechanically, do you have any suggestion for how to actually operationalize the meet and confer requirement?
Functionally and operationally, the way that we do it, and again, I mentioned in my comment that I couldn't do things the way I do them either if I didn't have my assistant, Julia Forgas. She's just unbelievably, I hate to even mention it because I'm so sure that everybody will now want to poach her, but what she does is she'll review the docket, and if she sees something that's set for hearing that doesn't have a certificate of good faith conferral, she cancels the hearing and contacts them. And sometimes she'll still be able to fit them back in. They say, oh, we actually did confer. So it's not meant to be punitive.
Right.
It's meant to make the point.
So that's interesting. One way of doing this is to tie it to the granting of hearing time. Like, hearing time can't be granted unless,
or it can be canceled, because we don't try to screen it in. We don't try to screen it before they reserve it. The other thing that we have done is, in clearly appropriate circumstances, and when the certificate of good faith is truly detailed enough for us to see what is happening, I have thought it was appropriate to grant a motion as unopposed. If someone shows me in their certificate of good faith conferral that they tried to confer, they can say, I called them on this day, on this day, on this day, I left messages, I followed up with voicemails, here's an email that I followed up, and I just can't get them to call me back. And that's a real thing. It's a real thing in really certain specific categories of cases in particular. The first party property world, I don't know what happens in that world, but they cannot talk to each other. So that motion could be granted as unopposed, and what is accomplished by doing that is that won't happen again in that case. The phone, when it rings, gets answered. And I wouldn't do that in a summary judgment motion. I wouldn't do that on a motion but a motion for extension of time, for example, because what is gained by not doing it that way? You know, what is gained by forcing someone to confer, and especially if it results in the denial of ability to get hearing time, when the other person can just say, well, I know what I can accomplish by not calling you back.
Right.
You just can't get your hearing.
Right.
So I think that there are specific mechanisms. But again, all these things, when you think about the unavailability of hearing time, the fact that the rules don't contemplate that they have to do that now is really astonishing. We're in 2024, and somehow the rules don't require a certificate of good faith conferral in every non-dispositive motion. And I say non-dispositive because I don't think we need people to confer on a motion for summary judgment. Right. Nobody's going to agree to that. So I did want to make one other point. And that is that when we talk about we talked about automation last time when we were here, and so we were talking about sort of systemically what could we do, what would be helpful. Automation is the answer for case management in Tampa, and the reason for that is when we first talked in November of, was it last year in November at the last oral argument, I was mentioning that I think that Tampa is essentially in 100% compliance with this court's requirement of having a case management order in every single case. And each one of them has deadlines that really mean something. We didn't even have a case manager until a couple months ago. And yet in Circuit Civil, we have 21,030 cases in Circuit Civil. That case manager also serves County Civil, which has 95,000 cases. So that one person we'll never be able to, what was amazing to hear is that Polk County's got a case manager who can be preparing and drafting orders and everything. We're so thankful for the one person we got a couple months ago, and that's one person for all those cases. So that, I don't know that there are enough people to be hired in Florida who are still looking for jobs to be case managers, if case managers are the answer for order preparation, at least case management orders. I'm out of time.
Thanks so
Thank
much.
you.
We really appreciate it.
Thank you.
May it please the court, my name is Russell Landy. I'm here on behalf of the nearly 6,000 members of the business law section of the Florida Bar. And we sort of don't, not plaintiff or defendant, most of our practice ends up being who got to the courthouse first, so we kind of look at it down the middle. We're very appreciative of the Rules Committee's proposals, and we agree with a vast majority of it. There's just 2 points that I'd like to highlight from our comment here today. The first one is we think that the concepts of proportion includes some conceptual things from proportionality, the apex doctrine, and also to resolve those issues with proportionality is something that's going to help resolve these cases, especially as e-discovery and the breadth of that grows and the broad jurisdiction of our courts that it's different than federal court.
Is there any concern among the section that we're making a lot of changes all at once? And as Judge Moe said, even a small change is a significant one in this area, that perhaps that's something that should wait, that portion should wait? Or do you think that that's, or does the section think that that's so vital to making this case management system work that you think it should be part of sort of the initial rollout?
I think issues are going to be resolved. If there's no other questions about proportionality, the other point that the section would like to talk about is the concept of the trial period. The section supports the Rules Committee's changes to 1.200 on case management, except for the proposed trial period versus trial period concept. And as Mr. Curry said, this is sort of something that came from the COVID administrative orders, but we think it should be a firm trial setting because deadlines are what move cases, and that's when parties know there is a trial setting coming, that's when they're going to do what they need to do, meet their deadlines, work to resolve cases. Having a projected trial date often leads to some slack in that system, and if parties don't think it's an actual trial date that's actually going, unfortunately, not any of our cases, but some of the cases are not going to get pushed and are going to languish in the system. I've had the pleasure to speak with Judge Moe about this concept, and we don't want to upset apple carts that are working in various jurisdictions, but there's some that may not be working. And each one has unique challenges for resources, technology, caseload, and those should be factored in to how this issue is handled. But the rule that that was proposed kind of provides for that because it says that it's consistent with the administrative orders of the Chief Judge of the Circuit. And we would propose that that stay in. And if there are unique needs for a certain circuit or jurisdiction to craft their orders in a way that makes sense, then they should. For example, perhaps it says, this is your trial period, subject to being pushed back for the court's needs. But the parties know that when that trial period comes, that's when they're going. And the other point is on if the trial period comes out from the initial order and it's an issue for the parties, the proposed rule in 1.200C5 provides that the parties can file a motion to modify the deadlines. And that's different than a continuance. If as soon as it comes out, the parties get together, say, hey, we're not going to get this case tried in this period. They can move for a modification of the deadlines, and it wouldn't be the concern of, oh, there's the continuance, and now we're never going to get a continuance. If there are any other questions, I'll take up less time.
Okay, thanks so much.
Thank you.
Just had a few quick points because I know we've been going for a long time. I did want to make it clear that there is tremendous support for Track A, for the Track A proposal. Obviously, the committee recommended Track A, but I wanted to point out that the ad hoc members that we had on that committee were very notable. We list them in our report, include numerous trial judges throughout the state, Peter Webster, Bruce Berman. Nobody from the ad hoc group said, you guys are making a mistake, you really need to go with Track B. Everybody seemed to support Track A. All of the circuits that filed comments supported Track A, again with some tweaks here and there. Business law section also, and several law firms from both sides of the V support Track A. So I think Track A is the way to go. I would recommend. One thing I think we've talked a lot here today about what I would call tweaks to the Track A proposal, and I think our response to the comments cautioned the court about Frankensteining. This is Ms. Luca's term, not mine. But there is, we all know the moral of the Frankenstein story, right? Don't do it. You're going to get a monster if you Frankenstein. And I think what Ms. Luca was talking about in the committee's response was that if you are going to get kind of crazy with, we're going to take this from Track B and put this over here, that's when the committee was saying we would like more time. If it's not, if we're talking about tweaks, I don't think we need to waste more time. So I just wanted to make that clear. There are places where more detail is helpful, but ringing in my ears is many of the trial judges who served as ad hoc members when we'd be going through some of this stuff saying less is more. Less is more. So there are a lot of areas, like when it comes to amending the the deadlines, and that's sometimes less is more. Leave it to the discretion of the trial judge. We don't need a rule that lists out the 45 reasons that something should be changed. So, expert disclosures mentioned, amending summary judgment deadlines, that sort of, also the meet and confer, those were obviously outside the scope of the court's referral. I think those are great subjects perhaps for a further referral to the committee. I know the committee is already looking at expert disclosures. It's not something that is simple to do. You know, we're looking at right now bringing in more of the federal concepts for expert disclosures into the state system. Right now, draft expert reports in state court are discoverable. They're not in federal court. There's no reason why there should be that discrepancy between the two systems, and that's something that the committee is already looking at. The last thing I wanted to say was about proportionality. The work group analyzed proportionality and found that in federal court, it does create more scope discovery issues right at the beginning of the case. And it works okay in federal court because there are magistrate judges to handle those issues. I think the work group's big concern was that we don't need those additional disputes, additional demands for hearing time at the outset of the cases when we're making all of these other changes. So
isn't proportionality, though, the right thing? Substantively, just in terms of just basic fairness and rationality?
Yes, Your Honor, and I haven't heard anyone from at least our committee say that the concept of proportionality is nonsense or is improper. It's that these things are already there for the judge's discretion, and perhaps the concern is if you plug it in that word and you draw that much more attention to it, that it will increase the amount of discovery disputes.
Doesn't it sort? I mean, people. It seems like bread and butter is just sort of fighting over. It seems like people are going to fight over it anyway, and it does arguably sort of shift sort of the baseline for what the argument is about.
Yeah, right. I think the way it works now is that, you know, the defense has to, or whoever the party responding to discovery has to file a motion for a protective order and try and find, you know, one of the reasons within the motion for protective order part of the rule. Whereas if it's clearly delineated that the scope of discovery includes proportionality, it probably makes it easier for someone opposing discovery to argue that it's not, doesn't work, doesn't fit for this case.
Okay.
Thank you.
Thanks. You guys really put so much work into this. We really appreciate it, especially since we kind of doubled your assignment. But we really appreciate it, and thank you very much. We'll be in recess for 10 minutes.
All rise.
probably part of the case. Oh, hang on. I need a bottle of water.
All rise. The Florida Supreme Court is now in session. Please be seated.
Our second and final case today is Kaler versus State, number 2023-0338.
Good morning, Your Honors. I'm Barbara Becheris, representing Matthew Kaler. I'd like to reserve 5 minutes of my time. Thank you. Mr. Kaler is seeking a new penalty phase trial in this matter because the attempt he made to rescind his waiver of a jury was rejected. He's seeking a new penalty phase that can be heard by a jury. I want to begin by talking about the point in time when it became clear that the reason for Mr. Kaler's waiver was no longer present. And that is the reason was no longer present as of January 2021. That is when the victim's mother in this case passed away. And Mr. Kaler did not know of that for several months. But during the months following that, he said on several different occasions when he attempted to waive a jury, as well as mitigation, as well as a couple of times his presence at proceedings, that the reason he wanted to enter these waivers was a promise he had made to the victim's mother that has been weighing on him.
Correct me if I'm wrong. I remember the phraseology of the promise, though, was about the family. It only became specific to the mother after he learned of her decease, right?
I disagree, Your Honor, with that reading of the record. The promise involved the family, certainly, that it was a promise to her that he would not put her and the family through proceedings. But when you look back, at one point he talks about how the victim's mother had, and this is going back years, had actually come to see him in person before his first sentencing, and that at that point in time he had told her that he was not going to drag
leaving all this aside. I mean, it seems to me the trouble with your position here is that the point of a waiver and the point of a colloquy before a waiver is dealing with changed circumstance. Anytime a right is waived, there is incumbent on the court and incumbent on the person waiving the right to make a decision that perhaps the circumstances will change. A waiver doesn't mean anything if it is not sort of reflective of the fact that things might change and you may come to regret that you have waived this right. It seems to me that the rule you're asking us to adopt is one that sort of takes the substance out of waiver and makes any defendant capable of saying, well, because of this changed circumstance or this postulate in my waiver, because that's now changed, it's not an effective waiver.
No, Your Honor, because the fact that changed before the waiver was even entered into. This is not a situation where Mr. Kaler knowingly entered a waiver being fully apprised of the circumstances, particularly that the person that he was trying to honor was deceased. And then later, the person tragically died, and he said, oh, wait a minute, now my reasoning has changed. What happened was that she was...
My question is, though, I mean, regardless of the timing, isn't this baked into the cake and the determination that this was, bad faith for the purposes of obtaining a delay? If we're looking at this from an abuse of discretion standpoint, this argument was made, the trial court considered it, may have been a credibility issue that the trial court made and reaching this conclusion. But regardless, how do we remove this from the kind of global determination that this was bad faith? Wouldn't it have to be some misunderstanding of fact from the trial court's perspective?
Well, the determination that this was made in bad faith for the purpose of delay, Your Honor, I don't think is borne out by the record when you look at the chronology of when different things happened. And certainly the trial court was as ignorant of the circumstances when Mr. Kaler's waivers were accepted as Mr. Kaler was himself. So
that's really the argument, that it has to be some misunderstanding of fact on the trial court's part for this.
Everyone was misinformed. The trial court.
But then at the beginning of the proceeding, when it comes out, your client just sits there. Doesn't say, oh, no, I don't want to do this. I want to revisit my waiver because she's dead. He didn't say that. It's months later that he brings it up. Isn't that correct?
Your Honor, my client, who was represented by counsel and who was appearing by Zoom, was taken completely aback at the news. His counsel did not say anything. The court did not say anything.
Your client's not.
The state did not say anything.
He's not incapable of expressing himself, I don't think, based on the record here.
He's very capable of expressing himself.
And so
yes.
but he waited 4 months, or wasn't it about 4 months?
There was a delay of about 3.5, almost 4 months before the motion was filed, during which he had to consult with counsel. And the record does contain, Your Honors, I wanted to point you to a document that was prepared by defense counsel in response to a request for a Nelson hearing after the waivers had been accepted and not withdrawn. It's on pages 628 and 629 of the record. It's a summary of contact by attorneys and support staff, but it verifies what the record suggests, which is that there was no contact between Mr. Kaler and his counsel until immediately before that motion was filed in March. So there was.
Can you provide, and I'm sorry to cut you off, but can you provide us with an example where a defendant's misunderstanding about a fact that seems to me to be totally ancillary to the right that he's waiving, that made the waiver unknowing. Can you provide us with any cases that supports that's, maybe on all fours or similar to what we are considering here?
Your Honor, I can't provide you with an example that's on all fours because the fact here, it is not ancillary. The fact here was Mr. Kaler's entire motivation for entering the waivers, which he stated repeatedly.
How is this case similar or dissimilar from Figueroa Sanabria?
Figueroa involved a misunderstanding as to the legal consequences.
Right.
So that is a difference, which is why I didn't cite Figueroa as being on all fours, but I do think that it's instructive that when there is a factor that truly subverts the defendant's ability to be entering into.
But the nature of the factor would have to come into play, right? I mean, in Figueroa Sanabria, it was because the trial court said something that was a misstatement of the law, right?
Correct.
Okay.
And here you have the trial court and apparently the state and Mr. Kaler all being mistaken about the fundamental reason for which he was entering into the waiver. But I do want to point out
the whole thing about a waiver is when people are going through waiving and there's the colloquy, are they asked why? Subjectively, they're waiving?
Yes, sometimes.
Is that part of the standard colloquy? Like, why are you doing this?
Oh, I don't believe it's required as part of the standard colloquy, but it was completely understood here that this was why he was doing it.
But all sorts of people can have all sorts of subjective reasons for why they want to waive the right to a jury trial. And sometimes that'll be known, sometimes it won't be known. And it just seems like to accept your argument would set us off down a course where people can come up and say, my mother died after I gave the waiver, and I only waived because I didn't want to put my mother through having to watch my trial. Okay, so you get all kinds of things like that based on these subjective reasons, and that's not the focus of the inquiry about whether a waiver is knowing and voluntary, is it?
In this case, Your Honor, it should be. And I do want to clarify, we are not taking the position that an after-the-fact change of circumstances is at issue here. But this is a situation where Mr. Kaler was attempting to waive a fundamental right, a right that our state constitution says is inviolate, a right that's protected by the federal constitution, which is to have a jury decide his fate.
Yeah, I know, but this, I think Justice Kennedy and I are going sort of the same point I started earlier, which is waiver has to mean something. And presumably, I'm at record 572 and 573. This is the letter from Mr. Kaler to Judge Patterson of March 25th, 2022. And he's going on in his own voice about how he would have never, made the waiver and describing his mental illness, his bipolar disorder. We may not, as part of a form waiver, inquire as to the subjective motivation of a person in making the waiver. But the trial court does assure itself of the competency of the person making the waiver. So the judge makes a finding that the person is either not on any mind-altering medication or has taken his or her medication, has confirmed that the person is acting voluntarily, has been advised. These are all parts of a normal colloquy. It seems like the basis for Mr. Kaler's withdrawal or attempted withdrawal of his waiver isn't really the subjective motivation. That's in the first part of the letter. But what he really says is, I'm dealing with my mental illness and there's chaos and the medication, I'm not getting as regularly as possible. So yes, I'd like to withdraw my waiver. And the trouble with that is the decision to make the waiver on the record was supported, I'm sure, by the colloquy of the judge into the defendant's present mental status, present voluntariness. I think the rule you're asking us to adopt just makes hash of what happens when a colloquy is taken in court. You're asking us to just nullify it because of its inconvenience and the regret that the defendant later has.
Your Honor, I respectfully, I don't think giving up a jury under a mistaken reason is an inconvenience. And I don't think that the surrounding circumstances of Mr. Kaler's mental health and other things
do you dispute that Mr. Kaler had adequate mental status to waive his rights when he waived them?
No.
You don't concede that? You don't dispute that?
I don't dispute it.
Okay, so your position is that the waiver was voluntary, and your quarrel is with knowing, but with respect to some subjective fact, not with the consequences of the waiver.
The consequences of the waiver are, and this is in, I apologize, I don't remember exactly where in the record it is, but it's in one of Mr. Kaler's statements. Mr. Kaler made this waiver knowing that it was 99.9, I think were his words, % certain to lead to a death sentence, to give up a jury, which at the time did not require unanimity. So he knew that that's what he was doing, and he knew he was doing it because of a promise to the victim's mother.
I guess the point is, I don't see, and I'd really like for you to respond to the difference between a fact external, however important it may be, a fact external to the decision of what are the legal consequences of my waiver. You're pointing to that external fact. I'll give you a hypothetical. Let's say that he had made the determination to waive his rights because he had no objective belief in the afterlife. And then he found religion. And now he wants to change his waiver because he thinks he has to do some kind of thing with his life. Your rule would allow him to take that external consideration and make it part of the knowing and voluntary colloquy before the court.
Your Honor, the rule that, to the extent we're seeking a rule today, is, I don't think would go that far. It would be that when somebody has made it clear throughout the proceedings that his goal in waiving something to which he's entitled is a promise, an external promise, yes. And when that promise is impossible because of the death of the promisee and the person is not informed, then the person should be given an opportunity to reflect on whether he wants to enter into the waiver. And I want to return to that moment that Justice Kennedy mentioned where Mr. Kaler did not object at the resentencing hearing. Mr. Kaler and his counsel had no idea coming into that hearing that they were going to hear that news. And apparently, in the record, the court did not know until that date, too. There is one party that knew ahead of time, and that is the state of Florida. And the state of Florida could have reached out to counsel and given them an opportunity to have this information and to object at the hearing. They could have started the hearing with, Your Honor, there's been a material change in circumstances for my client, or not even, I'm sorry, not a material change in circumstance. The circumstances don't exist because Mrs. McNallen, the victim's mother, had been dead since the previous January. And the state of Florida didn't do that. The state of Florida sat there while defense counsel said, could we confirm with Mr. Kaler that this is what he wants to do? And only after that did the state of Florida say, oh, and by the way, she's dead, but we have her victim impact statement right here. So I think you have to consider that in the context of what happened in that hearing. Again, and the fact that Mr. Kaler was with counsel who did not object, and that a motion was filed apparently as soon as he was able to confer with counsel. And I just want to, I'm getting towards the end of my time, so I just want to, in addition to that, note that under the standard that this court developed in Floyd for retracting a waiver or allowing somebody to retract a waiver, Yes, Justice Sasso, you mentioned the trial court's finding that this was made for delay, which I do not believe is supported by the record. Again, if you look at the chronology. But the other Floyd factors weigh completely in Mr. Kaler's favor. There was no evidentiary proceeding that would have to be undone. The only thing that had happened at the sentencing hearing was that documents had been entered into the record. And in fact, even when that hearing was closed, the court was still explicitly waiting for a state report from an expert retained by the state. So clearly this was not the same thing as somebody going through an evidentiary proceeding, the expense of a trial, calling witnesses, and then trying to change their mind. So if you look at it under those Floyd factors, Mr. Kaler should have been able to exercise his right to a jury. And if you have no further questions, I'd like to reserve the remainder of my time. Thanks.
you.
May it please the court, Charmaine Millsaps representing the state. I would like to get right to the heart of what knowing for a waiver means, because that's really the claim here, that the waiver was unknowing. And I'd like to quote from the Figueroa case, citing the United States Supreme Court case of Ruiz, and you say the law ordinarily considers a waiver knowing, intelligent, and sufficiently aware if the defendant fully understands the nature of the right and how the right would likely apply in general. You're quoting the United States Supreme Court there. Your Honor, the knowledge that you need for a waiver to be knowing in the legal sense is the knowledge surrounding the right you're waiving. What this would have to be was some, as happened in Figueroa, some misinformation regarding the right at issue. Here, somebody would have to say this claim to be really having anything to do with what we mean by knowing would have to be a misapprehension or misinformation about the right to a penalty phase jury during a resentencing. This allegation doesn't even come close to this. There's a complete disconnect between what you need to know for a knowing waiver and this claim. It's quite frankly, the mother's death is, in terms of whether the waiver was voluntary, is completely, it's a non sequitur legally. The misinformation has to be connected to the right you're waiving, or the consequences of the right. Here, what he would have to be told is what a penalty phase jury's purpose and role is, and then the consequences. For instance, here the consequences would be this would turn into a bench penalty phase where the judge alone would make the factual findings, where typically if you had a jury it would be in conjunction with the jury. None of this is a complete non sequitur.
I agree with your argument. And yet I am curious whether the state did in fact know about the mother's passing prior to the colloquy during which Mr. Kaler waived this right.
Well,
was the state aware of it?
The prosecutor must have known before he walked into the penalty phase. Your Honor, I can tell you, I do not know is the answer. Normally, we find out from the victims when some proceeding is coming up that the victim's going to be part of, or a major stage of the case. It's a few weeks before that. So just from my own experience, I usually find out about whether or not the victims are going to come to an oral argument, for example, just a few weeks before the oral argument. We contact them, I think, 4 or 5 weeks before. So I suspect the prosecutor only knew before the November penalty phase a few weeks, but there's nothing in this record about that. However, that's not Brady.
When did the waiver happen?
The waiver was in May. The waiver colloquy?
Right.
Yes, the waiver colloquy was in May. The mother died in January of that year. then May was the waiver colloquy, and then November was the penalty phase, the bench penalty phase. Okay? But I'd also like to read, in Figaro, you relied on Ruiz, and Ruiz has a part that literally says, where they're talking about, that was the whole issue in Ruiz, how thorough a defendant's, how complete, in the words of the United States Supreme Court, a defendant's knowledge has to be. There, they didn't get Brady material for a fast-track plea. And the United States Supreme Court said fast-track pleas are still valid, even though you do not have much more relevant information, the information that the government's going to present against you. But in Ruiz, it says, in respect to a defendant's awareness of the relevant circumstances, it does not require complete knowledge, but it permits a court to accept a guilty plea, which is a form of waiver, with its accompanying waiver of the various constitutional rights. And here's the money quote: despite various forms of misapprehension under which a defendant might labor. And it cites Brady versus the United States, which is the case I relied on in my brief. Your Honor, it's pretty clear that even if a defendant, from this language, admitted dicta, but dicta from the United States Supreme Court, that a defendant, even a mistake of fact that's not related to the right at issue, a mistake of fact that's not related, that's a misapprehension, that's misinformation, but that is unconnected to the right at issue, does not render in that case it was a guilty plea, but does not render a waiver involuntary. They're literally, the United States Supreme Court doesn't care about other forms of mistakes that aren't related to the right at issue. I would like to point out also, there is a prosecutor wouldn't really have.
Can I ask you quickly on standard of review, with that being your argument, do you still see it as abuse of discretion, or do you say regardless of how the court interpreted this argument, it would have been legally insufficient regardless of when the
As a matter of law, this claim does not give rise, cannot support an unknowing as a matter of law, but that does not change my argument. It's alternative. I think I went on both the facts and the law. And this was a finding by a trial court that this was made in bad faith, that this motion to withdraw the prior waiver of the penalty phase jury was made, and here's a quote, in bad faith for purposes of obtaining the delay. And the record fully supports that. The trial judge really relied on two main reasons for that. One was the over 4 months, just a few days, over 4 months delay. And remember, this defendant was informed twice at the bench penalty phase by two different sources. The prosecutor, right after the judge asked the defendant to reaffirm his wanting to waive, literally turned the page. The next page, the prosecutor tells everyone in the courtroom that the mother has died. And then later, the grandfather of the victim, who is the father of the mother, in the victim impact that is being read to the court, that is also included in that letter. So two different sources at two different times tell him. And he has no trouble writing letters to this judge. This record is full. So I don't think, yes, you may want to talk to counsel, but that needs to be done very quickly. He should have asked for a break right then if this was his sole motivation. But I'm just saying the judge could say, even in response, if that had happened, that's not what the law cares. That's irrelevant, legally irrelevant to knowing. And if he wanted to enforce that waiver, he could. Just one more thing about Floyd. The argument here seems to be that the judge really did, not very many judicial resources were spent, because the penalty phase here was admittedly, because of both the waiver of the jury and of mitigation, was a very short thing. Basically what happened was the transcripts from the first penalty phase came in for purposes of Mohammed, And then the victim impact letters were read, and they were going to let the defendant talk, but the judge said you can do that at Spencer. Admittedly, it was very short, but we do not redo entire proceedings just because they didn't take days and days and days. And secondly, we don't even know that's true. The judicial labor involved here, we don't know if the Judge Patterson very well may have started reading the penalty phase transcripts from the first to start preparing his sentencing order. We have no idea how much. The only thing we know is the judicial labor that happened on the record. There may have been much more back in chambers, but regardless of how much time was spent, you do not redo an entire thing. I think this is the judge's findings that changing your mind and waiting 4 months is bad faith are completely supported by this record, and there is no abuse of discretion. When a judge has made basically a factual finding of bad faith that is supported, both those are undisputed. It's undisputed that this motion was 4 months late, really, and that the defendant had a history all through this proceeding of changing his mind. We ask you to affirm the sentence following the Hurst resentencing. Thank you.
Thank you very much.
Your Honors, regarding the defendant changing his mind, there is only one period of time during which Mr. Kaler's indecision about his waiving arguably caused any delay when proceedings weren't already delayed for other reasons. And that is the time period between when he found out in November that the victim's mother was dead and when his motion was filed. And I would, again, direct you to that summary of context with counsel and the defendant as evidence that this was not an unreasonable delay. It was not done for the purposes of delaying the entire proceedings. This motion was filed as soon as Mr. Kaler was able to consult with counsel about the consequences of what he had learned at the November hearing. I also want to point out that at that November hearing, he was told if he wanted to say anything, he could, but that he would be sworn and questioned and subject to cross-examination. And so it is understandable that he agreed to wait until the Spencer hearing. And in fact, this motion was filed in advance of the Spencer hearing being scheduled. I want to quickly go back to Floyd. When you remove the bad faith finding, which I don't believe is supported by the record or the chronology, Floyd says that the trial court's discretion should be exercised liberally in favor of granting to an accused the right to a trial by jury. That could have happened here. And our position is that it was an abuse of the trial court's discretion in the context of the way these waivers were made and then attempted to be withdrawn, to deny Mr. Kaler that jury for his penalty phase, which is a significant right, and one that he knew when he gave up he was basically acquiescing to the reinstatement of a death sentence. That was clear from the record. Floyd says that unless some real harm will be done, unless there will be real inconvenience to the court or the state, that the importance of the right to jury should lead the court to exercise its discretion in favor of giving someone a jury trial. And so if there are no further questions, Mr. Kaler requests a new penalty phase before a jury. Thank you, Your Honors.
Thank you. We're adjourned.
All rise.